I want to thank Senator West and the Attorney General's office for working with us on this legislation. This legislation deals with, as I had mentioned earlier, federal waivers and making sure that the state complies with some requirements. The pandemic we saw caused delays in the processing of child support. We're also facing some deadlines with respect to the federal waivers that allow the Office of the Attorney General, counties, and our courts to run more efficient child support enforcement programs. This bill helps the Title 4D program, which I had referenced are the courts that oversee the child support in Texas. It helps that program by streamlining certain processes and statute and providing more flexibilities to the counties and the courts. So first, I'm just going to give some quick background on the system, and then second, how this bill streamlines the process. We have a resource witness here with the Office of the Attorney General who can clarify or answer any questions as well. Just quick background, the Integrated Child Support System, or ICSS, is one of Texas's mechanisms by which we implement Title 4D of the Social Security Act of 1975. That mandates that every state create a child support enforcement program. In fiscal year 2020, the Child Support Division in Texas served over 1.6 million children, and this number is on the rise. So every 4 Texas children is served by the system. 19 counties in Texas have chosen to be a part of that. Dallas County, Tarrant County, and others are part of ICSS. And they adopt a federal waiver that allows newly established support orders to automatically become Title 4D cases. I'm just going to just in the interest of time, cover a few of the sections and then defer to the resource witness who can clarify some other things. What this bill does is it addresses barriers to the implementation of the child support review process by allowing the use of digitized signatures and unsworn declarations in order to complete the child support review process documents. It also clarifies that a court may approve the use of substituted service to serve a non-agreed child support review process order on a party. It increases the time frame for judges to review and sign the agreed child support review process orders, and also increases the time frame before agreed orders become confirmed by operation of law. It also incorporates into the statute several federally required standards that a state must consider when conducting a review of the state's child support guidelines on a quadrennial basis. And it clarifies that a record of a court order for child support that is submitted by the state case registry should also include the records regarding medical support and dental support. I'm happy to answer questions, and I respectfully reserve my right to close.
Oh, I'm sorry. You just switched the gavel back to me. Members, are there any questions for Chair Nayave? All right, if there are no further questions, we'll proceed to testimony. The chair calls Joel Rogers. And next up will be Tarrant Champagne, Angela Igerson, and Jane McMahon. So if y'all can be ready to go, that would be great. Mr. Rogers, if you could state your name, who you represent, and your position on the bill.
My name is Joel Rogers. I'm Associate Deputy Attorney General for Child Support Legal Services with the Child Support Division, and I'm here as a resource witness testifying on the bill if there's questions.
Are there any questions for this witness? Members? Well, I guess you got off easy this time.
Appreciate it. Thank you.
Okay. The next person is Tarrant Champagne. The chair calls Tarrant Champagne. Please state your name, who you represent, and your position on the bill.
Good afternoon. My name is Tarrant Champagne. I am representing myself, and I am neutral on the bill. I'm just commenting on the bill. So when you look at the Title 4D program that is being affected by this bill, you should be aware of kind of what this represents. Based on information from the Office of the Attorney General, this is approximately 1,495,302 cases. This is as of November 29th, 2020. These Title 4D funds are distributed to all 254 counties in the amounts of $24,261,130.70. Relating to this, obviously, what this bill relates to the clerk of the county. The clerks of the county are incentivized and the counties by extension to increase child support collections related to this. For example, Travis County has 6 agreements with the Office of the Attorney General, the Title 4D agency. And in state fiscal year 19, they received $1,701,554.91, of which these contracts were the state case registry agreements, which I believe Chairman Neave spoke on, the integrated child support system contract community supervision, and then there are 3 further non-contracted agreements, one which is with the district clerk, and also with the Travis County Precinct 3 and Precinct 5, I believe. The integrated child support contract, the incentive that comes from this is based on a per case amount that is given to the county for each case that's assigned. They are given $17.72 per case and get a quality and efficiency payment of 40 cents per case. In state fiscal year 19, this represented $45,000 per month. The community supervision contract is based on $46 per month, and the county received $43,000 per month. Finally, the state case registry, which the chairwoman mentioned in her case, is based on new cases or updates to the Title 4D cases, which represents a $12.89 per new case, or new or modified case, or $4.09 per activity. The district clerk specifically who files these in Travis County received $474,932.70 in state fiscal year 19. What does this all mean? Why am I talking about this? I want you to consider the ramifications of what Title 4D represents. Title 4D gives money to the state to encourage them to separate children from parents and create a custodial and non-custodial parent, as is based on the term non-custodial parent, is how they generate their funds. This is a cash for kids profit generating scheme. I encourage all of you to look at the Texas state plan submitted by the Office of the Attorney General to get a better idea of what this represents. For example, we paid in state fiscal year 19 almost $1 million to the state of Rhode Island for lien services. And that's my testimony. Do I have any further questions?
Members, are there any questions for this witness? All right, seeing none, we appreciate it.
Thank you, ma'am.
The chair calls Angela Igerson. Please state your name, who you represent, and your position on the bill.
Good afternoon. Thank you, Chairwoman Swanson. I was expecting to say her name. And committee members, I appreciate you listening to me. My name is Angela Igerson. I'm the Dallas County Domestic Relations Office Director, and I am here in support of this omnibus, House Bill 2953, the Title 40 Omnibus Bill. I had my prepared statement, and I'm going to add a little bit based on the prior person. I'm here today in support of the bill, and I report to the 7 family district judges of Dallas County, one of which is Andrea Plumley, who just heard from. I got off the phone with her last week in reference to this bill, and she provided her wholehearted support in reference to the program that the Sections 1 and 3 specifically allow Dallas County to participate in. The sections allow for the continuation of the successful program that we've had in Dallas County for 16 years. And in fact, this bill opens the door for statewide services, so it's not limited to the contract ability anymore. And it provides, allows child support enforcement and modification services as soon as orders are entered, not initiating them, and before large arrears can occur. This is a win-win program for both the recipients and the payers of child support. If a modification needs to be done up or down, we've seen a lot of that since 2008 in particular, and then again recently this year, we can react. People do not have to hire their own attorney. This is a benefit to every citizen that we can provide in support of the best child support program in the country, as previously testified to. The changes in the statute may seem trivial, but I urge you to ensure the swift passage of this bill so that time doesn't run out, as the failure of the passage would have a profound impact on the services that my domestic relations office and others around the state can provide. Thank you for your time.
Members, are there any questions for this witness? I have one. Could you just say a little bit more on the clarifying when the county is involved in collecting child support versus when the state is?
Okay, sure. I'd be happy to do that. So the state is mandated through these are all federal pass-through dollars, first of all. So this is not a state item. This is federal pass-through funds. That makes a difference. So they are mandated, the Attorney General's office is mandated to handle those TANF cases that we referred to earlier, the ones where they're receiving other benefits that they may be trying to get reinforced. We are taking cases where it's a final degree of divorce or a final paternity that's already happened. We're not involved in that front end. We're not out there establishing paternity at this time. We are taking an order that comes, and then we are putting it immediately into the program so that wage garnishments can go out immediately. People don't have to figure things out. All of the tools that are available to the Attorney General's office, we use their system, and we're able to benefit from that by finding employers and sending garnishments and things like that. So our caseloads, if we find out that we've opened a case and a party maybe is already receiving benefits that is required, we are required to send those back to the Attorney General's office. So there is quite a separation between the types of cases that we handle, and that's kind of the biggest thing that I can say is we have no benefit cases.
State assigns you that particular type, or the county never sends them to the state, or how does this work?
Up until this time, there's been a waiver that has been granted through the federal government to allow the Attorney General not to provide statewide services. They were able to do individual contracts. The counties had to be willing to participate. The counties have a financial responsibility to participate in this program. It's not 100%, reimbursement. And the waiver has been gone away. Office Court Administration has determined it. We know it's a successful program. They're happy to have it, and they want the state to apply it statewide. That's why I mentioned that in my
Okay, thank you. Any further questions for this witness? All right, well, thank you. The chair calls Jane McMahon. And if you would, please state your name, who you represent, and your position on the bill.
Good afternoon, thank you. My name is Jane McMahon, and I'm the Director of the Legal Services Division of the Harris County Domestic Relations Office. And I'm here today to express our support for House Bill 2953. For approximately 17 years, the Harris County Domestic Relations Office has successfully served thousands of Harris County families enrolled in the ICSS program through our partnership with the Attorney General's office. We believe that the reason that this program has been so successful is because it's an early intervention program, and we get those cases as soon as the court order is signed, rather than the parties waiting until months or years later when they have a problem and they need our help. We found that making contact with the parents shortly after the divorce decree or the other order is signed not only provides them with important resources, but also creates what we call a culture of compliance, and that results in children receiving more consistent child support throughout the life of the entire order. Currently in Harris County, we have approximately 17,000 cases in the ICSS program. And last fiscal year, we collected in Harris County alone about $173 million in child support. As this bill provides, adding the option in the record of support for a party to apply for 4D services is vital to the continued operation of the ICSS program in Harris County. Currently, the new cases come into the program, as has already been explained to you, automatically unless the custodial parent opts out. Unfortunately, the federal waiver is expiring in September, and the cases will no longer be able to come into our program in that manner. So this legislation allows a very simple solution, adding a signature where parties can apply for the service on a record of support form that's already in the code. Some people are already using it. And so that will allow these cases to immediately come into our program when the order is filed. In case you're not familiar with our program, what we do in this program is we monitor and enforce child support and medical support. We pursue modifications, whether it's increases or decreases, which has been very helpful for many families during this pandemic. And we're able to tap into other 4D resources, such as federal offsets, employee new hire, some of the other things. So this program has made us much more efficient and more effective, and we urge your support. And I'm happy to answer any questions that you may have.
Members, are there any questions for this witness? All right, seeing none, the chair calls Clint Depew. If you could please state your name, who you represent, and your position on the bill.
Good afternoon, Chair and members. I appreciate you calling us here. And my name is Clint Depew. I am the Director for Legal Support Services in Tarrant County, Fort Worth. That's my tie and all that stuff. So this bill, it's important because so many people have already come to rely on the services that we provide. It's child support, and it's making sure that the support is paid through the system that gets to the parents. It is not a for-profit child. We make no determination on who the CP is or who the NCP is, so please do not get confused with what the purpose of this is. This is a service that, as Jane explained, that helps individuals and it helps families. But not only is it helping families, it's also helping attorneys that go through, that rely on these pay records and to make sure that this child support is being paid. It allows the attorneys to have fact-based evidence, not presumed evidence or anything like that. It's fact-based evidence. There's lots of services that go through. We do not profit off of this. This is not a for-profit machine or anything like that. It does not cover our expenses. For me personally, for the legal support services, it does not pay for our team of attorneys or anything like that. It goes straight to the monitoring stuff that's in a whole different department. But it is a system of series of events and a series of services that have really, really become relied upon we're in our third decade now of this. And it's really a no-brainer. It's common sense. Attorneys use it, the judges rely on it, and the families desperately rely on it. And it's something that the counties have already invested in, and we're just hoping to keep that program going and allowing it to go through the ROS and substitution of the waiver going away will help keep the program going. So.
All right, members, are there any questions for this witness? Seeing none.
Quick question.
Oh, yes, there is one. Yes, Representative Cook.
Thank you, Madam Chair. So what was the last thing you said, keeping it going through the what?
The waiver is going away as of September 1st, 2021 of this year through the Health and Human Services, which I think they all talked about.
Right.
So the proposal in this bill is to get it to go through the record of support, which is a form that people are already filling out. Attorneys fill out and parties fill out to talk about child support, like where it goes from who to where and how much and stuff. It just allows the application for state wideness to be signed on that record of support, so it makes it very seamless.
Right. I just want to make sure what term you were talking about, because record of support, definitely with you now. So.
Yeah, sorry about that. I probably didn't make that
problem.
clear.
Thank you.
So.
All right, any further questions for this witness? All right, hearing none, are there any, is there anyone else who wishes to testify on, for, or against this bill, House Bill 2953? Seeing none, the chair recognizes Chair Nayave to close on the bill.
Thank you, members. I ask for your favorable consideration of this bill.
Oh, that was quick. House Bill 2953 is left pending.